Good morning, everybody. Welcome to Foster Swift's What Employers Need to Know for 2022 webinar. We appreciate you joining us this morning. We have a very informative session and we'll keep the introductions quite short. The other thing I'd like to remind you is today's session is general information only, and we do encourage you to always check with your legal counsel prior to taking any action so that you know specifically how the law applies to your particular situation.
Another issue that comes up, and it's been continuous, but I guarantee it's going to be even bigger in 2022, because I've had more situations with non-competes, whether defending them or enforcing them in the last year than I've ever had probably in the last 10 years combined. People are really worried about their workforce. They want to keep their people. They want to keep their customers. And what's going on is everybody's having non-compete issues. They're fighting over employees going somewhere else, stealing their clients, stealing their customers. And it's a big deal, and it's going to get even more complicated next year. So, and Kim, if you can go to the next slide. What is a non-compete? We hear about this all the time, but it's basically really simple. It's a contract, really. It's a contract. It's not something in your handbook, right? It's not good enough to put a clause in your handbook. You actually have to have something in writing that's a contract that says it's going to prohibit somebody in the same business to compete against you if they leave their job, all right? Now, the point is to protect you as an employer from somebody leaving and taking your knowledge and your trade secrets that they learned with you to go help somebody else and help themselves compete against you. Very important. What it is not and what it should never be is a way to stop competition. If you have a non-compete because you don't want competition and that's the only reason, it's not enforceable. And if you say that, no, that's going to get you in trouble in front of a judge. What you're trying to do is you train people, you let them in the inner sanctum, you give them all the good secret sauce that you have as a business, the contacts you have, the business structure, the accounting, the nature of the business, how it runs, all these things that you put time and money into as a business, and you learn how not to do things, how to do things. Those things are what you're trying to protect. You don't want a person to learn all those things you put all that time and value in, walk down the street and start their own company. Walk down the street and give it away to a competitor. That's not fair competition. That's why they're allowed to be in place. So again, it's not to stop a person from making a living. Please go get a job. Go work wherever you want. Just don't take my stuff and take it to a competitor. So non-compete is for the purpose of keeping and protecting your trade secrets, your knowledge, your business acumen, all those things that make a business. That's what it's for. And that's why it's easier to enforce a non-compete against a higher level person than it is a rank and file. If you remember a couple of years ago, Jimmy John's, I believe it is, was having their sandwich artists sign non-competes. That's an awful tough one, right? Because they were saying, well, you know, we told you how to use the conveyor belt there of all the different tomatoes, lettuce, and all the meats. And again, it's difficult, right? The lower the level, the less stuff that they have access to, probably would have a harder time enforcing a non-compete unless you're just trying to stop that person from going down the subway and taking that skill. So if you have a rank and file employee, beware, it may not be quite as enforceable because you have to show that there's damage. So you want to draft it properly and you want to make sure you're protecting legitimate interests. So Kim, if you can go to the next slide. Under Michigan's law, you have to draft your agreement the right way. And it has to, number one, be drawn narrowly. In other words, you got to make sure you're protecting what it is you want to protect. All right. And it's got to, as we talked about, protect a reasonable competitive business interest. You can't just say, I don't want people competing. That's not good enough. And it has to be reasonable. And this is very important. Everybody hears about this. Duration, geographical area, and the type of restricted employee or line of business. So in other words, let's just say I own a watch repair shop, and you come to work for me, and you're repairing watches, and it's a very technical, competitive business because there's only so many people that can, fix a Rolex, right? And I train you, and I put all the skill in there, and I have you sign a non-compete, and I say you can't work anywhere in the world for the next 74 years in anything that has a clock on the wall. Well, that's crazy. You can't do that. That's just why. It's not reasonable. Let's talk about geographical area. Now, let's just say there's only 20 qualified Rolex people that do what I do. and they're all over the world. That geographical area actually might be reasonable if I service watches from all over the world. But if I only have 5 customers and they all come from 30 miles around, then that would be a reasonable geographical area. If I am in a little shop in a mall and I only get people trafficking through, yeah, you're going to have a hard time drafting up a statewide restriction. So again, the geographical area is going to depend on what type of business you have, who you service. And again, you could say all the places that my business does business in, that might be legitimate. All the places we have, all the customers and all the areas that you have, you may be able to geographically restrict them reasonably to the area you do business or that you solicit business. The duration, if you get after 1 year, anything longer than a year, you're into what I would call the gray area, right? 18 months is probably pushing it. 2 years is really pushing it. 3, 4, 5, you better have a legitimate reason why you're doing that. There could be, again, some very specific skill set that this person has that is so valuable that it doesn't dilute over time. But again, if you're just trying to make the person not work, that's not fair. If a person's got to move outside the area and they've got a rather long duration, but it's because they're a high-level employee, that could be legitimate. But again, your mid-level to low-level person, if you're just saying you can't work for any place that does anything we do, and again, let's just say you work at a tire place and you fix tires and you rotate tires, and you say you can't work for any business that does any of the business we do. And so they go ahead and get a job as a janitor at General Motors in Indiana. Now that's ridiculous. Again, the geographical scope is too long. And if you say you can't do it for 3 years, it's going to be too long in the time. And again, the type of restricted employment and the line of business will sometimes dictate what you're going to do. You want to tailor it to what they do, because what you don't want is somebody going maybe to an unrelated business, but they're giving away your trade secrets because they have another area that they can actually provide the services to. So that company where they're working, they may not be doing that job, but somebody else in that place does do your job, and you may impute your knowledge to them. So again, that could be more reasonable depending on the circumstances. So again, it depends on the facts, it depends on the job, and you have to draft it right so that you can get an injunction, which means you can make them stop. And in Michigan, you can actually go after not only the person, but the company they're working for. And you send them a letter and say, I just want you to know we've got a non-compete agreement. They're bound by it. And guess what? If you keep employing those individuals or that person in violation, we're going to come after you for the same damages. So it's very important. So if you're an employer and you're hiring somebody, you go, I don't care about that non-compete, better watch out, because that last employer could come after you. So be very careful. So when you're in the hiring process, what I would recommend is you ask somebody, because this is becoming a big deal, are you under a non-compete agreement? Do you have any restrictive covenants from your old employer that we should know about? Then you can review them and take a look and say, okay, I think we're good. Or you can sit there and say, I'm not hiring you. I'm not going to hire you because of that. So it's an important thing to remember. It is becoming big. And it has always been something. There's tons of cases and they go all over the place on whether they're enforceable and what are the damages. The biggest problem is a lot of times courts don't know how much to give. Like, what's it worth if I bring a low-level person over in technical violation? I mean, how much is that worth? $1 million, $1,000, the replacement cost of replacing you? There's just a lot of different damages out there. So Kim, if you can go to the next slide. Now, the president does not like non-compete agreements. He does not like them at all. In fact, he's saying, look, I want to get rid of these things, all right? And he says basically he'd like to have a new standard for enforcement, okay, to narrow it down to really high level, highly paid, highly compensated executives. Maybe you have a good reason for that, but your average person, he's saying this is not competitive. America is supposed to be about, you get up in the morning, you get a job, and if you can find a better job, go get it. Why restrict employees from coming to work? You got the best, most talented people out there who have got skills. They got off their butt. They went and worked for you. You gave them something, but hey, they're the ones that earned it. That's why you hired them in the first place. So let's knock it off. And he's actually tasked his agencies to go out there to define rules to stop this. And he wants to say, hey, look, is there a way that the Federal Trade Commission could say this is anti-competitive behavior. So beware. They are under attack. A lot of courts don't like them. Some states don't like them. Indiana, for instance, if you lose a non-compete case, it's almost automatic that if you bring a case against an employee to stop working, that the employee may win against you for restricting trade, a tortious interference with their ability to do business. Some places just outright just say you can't do it. Illinois, California say you can't have them. Now you can have protections of your confidential information. So make sure you have that in any agreement that you have. So you can stop people from stealing your secrets and going to a competitor. But what they say is you can't stop them from going to work for somebody. And that's a fine line because I'm going to work for a competitor, but you have all this secret information. It's almost like you still have a non-compete, just under a different term. And again, there's other ways you can restrict people. Non-solicitations. Non-solicitations can mean two things. If you leave, don't ask my former employees or my employees to leave with you. That's one type. Or don't come after my customers, my suppliers, my people that I do business with. Don't take them away for yourself or somebody else under a contract, and don't solicit them, whether they're my customers or people that I had gone after. You knew I was going after this person. Don't steal that. So again, the administration probably is okay with those type of restrictions because that's stealing stuff instead of taking your knowledge and yourself and going out and getting business. So if you can go to the next slide. Kim, can you go to the next slide, please? Now, what's the rationale? Again, you're stifling workers' job mobility and wage gain, right? So what they're basically saying is, if I could get a raise and you're not giving it to me to go someplace else, why shouldn't I be allowed to go? Because you're stopping workers from making more money. A lot of businesses just hate this idea. They think it's not fair. And a lot of employee advocates say it's ridiculous to be able to stop people. So you're never going to make both those sides understand each other's. But just want you to know in 2022, this could be coming down. So when you are drafting your agreements, the question is going to be, you need to know how far, how much you want to push on the non-compete. But really what you need to do is start taking a look at your confidentiality provisions and agreements, and just taking a look at all the I would say peripheral issues, which is don't steal my customers, don't steal my protected client information, my billing, my other types of protected, how do I go out and make my business run? Those types of things, as opposed to stopping the person. Okay, you can still have the non-competes, but just know they may not be enforceable. So draft them broader so that you can have more things protected other than just simply don't go out there and work. Going to the next slide, please. So according to the president, he says it's simple. Companies should have to, compete for workers just like they compete for customers. And so that's it. Now, this is where we get into a completely different issue. And I want to make sure everybody here, they leave one thing that's very difficult to get. It is the difference between a no-poaching agreement and a non-compete clause, because they are different. And this is criminal behavior. And it's very troubling sometimes when you see employees or employers getting into these agreements, because it could spell serious consequences for you. If you go to the next slide, Kim. Now, what he wants to do, the president I'm talking about, is eliminate non-compete clauses, but he is right now trying to ban no-poaching agreements through the use of the Department of Justice in criminal complaints. Next slide, please. A no-poach agreement is different. That's where employers agree between themselves not to hire each other's workers. It makes it hard for workers to get a job with a competitor. In fact, Department of Justice and Federal Trade Commission antitrust guidance says it's against the law for employer wages or not to hire another's workers. So you can't set wages between two employers saying you won't pay more than this, and you can't say you won't hire each other's workers. Sometimes what will happen when you get a non-compete case, employers will want to settle by saying, okay, well, I won't take your employees for so long, you won't take my employees, and we'll all be happy. That's actually criminal. And I want to repeat this. Two employers agreeing they won't hire each other's workers if they leave is potentially unlawful criminal behavior. Be extremely careful not to be setting a standard in the industry to not take each other's people. You can abide by non-competes, which is between an employee and the employer. I agree, I won't work for somebody else after I leave, whether you fire me or I quit, is between me and my employer. But if an employer reaches out to a competitor and says, we won't take any of your employees, that's different. So let me give you a scenario. I sign a non-compete with you. I leave. I go to your competitor. You write a letter to the competitor and say, I just want you to know that person signed a non-compete. You need to fire them or assure me that you're not using them the wrong way. And you say, you're right. I'm not hiring this person anymore. I didn't know about this. I'm firing them. That's okay as long as a non-compete is legitimate. That's okay and not non-poaching. That's not a no-poaching agreement. What that is an enforcement of a non-compete. What's not okay is, I notice I have 15 people that went from my place to your place. I can't find employees. I call you up and say, I've had about enough of this nonsense. Now you need to stop hiring my employees in the future. What do you need from me? And we make a pact where we're not going to, hire each other as employees. That's a no poaching agreement. Fine line. It's extremely fine line because it sounds like very similar behavior, but just be careful. Okay. And if you go to the next slide, please, Kim. So you don't want to expressly do that, number one. So if you're an HR professional, you got to take steps to ensure the interactions with other employers in the competitive business does not result in a problem where they're not competing. Okay, so you just have to be careful when you're out there socializing or you're at events like that. Just be careful you're not creating a no poach situation, even if it's not in writing, so that situation doesn't arise. And next slide, please. Now, an individual is likely breaking the law if they agree with individuals at another company. So again, it doesn't have to be in writing, okay, about the salaries, other terms of compensation, because you're now fixing how much people are being paid, or agrees with individuals at another company not to solicit or hire somebody. So sharing information with competitors about how much people are making, how much money and what the benefits are, could get you in a position where you're fixing the market, where you're having a problem. So be careful. There are different ways that you can do this, but sometimes you'll get industry solicitations to say, hey, what's the general wages? That's different. But when you're just sitting there talking, hey, how much you pay? 15? Oh, me too. Or I better raise mine so we can all be in the same ballpark. Be careful. Just be careful with that. And I know right now it's very tempting because we're having a hard time attracting talent and everybody's going around. So be careful not to price fix, not to salary fix, not to get into a situation in 2022 where you're doing everything you can to make sure you're at market, including setting the market. Okay, so go into the next slide, please. An individual that thinks that they've actually been violated can get a civil suit as well as the criminal suit and get triple damages. Triple damages. If they believe that you've price fixed or you've got a poaching agreement. So be very careful. And the Department of Justice could bring a criminal prosecution against people. Okay, so it's very important. In fact, right here in Michigan, you've got one going on right now in addition to these ones in Texas. And we'll talk about here, but in Texas in last year, they had an indictment for charging former owner of physical therapist staffing company for fixing. You got another one indictment, charging 3 outpatient medical care, suppressing competition through no poach agreement. So they're out there. They're coming after people. Next slide, please. And this is the one in Michigan. This is CRNA filed class actions, so saying that, hey, they were doing unlawful poaching agreements between other businesses, anesthesiologists. So you got to be careful because they're asking for treble damages. There's a current motion to dismiss pending, but we don't know if that's going to win, and it's going to be tough to win those kind of cases. Now, I don't know all the facts and factors because that case just started, so I can't say that they're going to win or lose or whether it's true or not. I just know there's a case out there right now. So just a significant civil and criminal case that's out there in 2022. So be careful on how you draft your agreements. Be careful how you interact with your competitors. And just understand that in addition to COVID, there are restrictive covenants when we're starting to fight for employment talent. that are out there so that you don't do everything that you can to get people, including breaking the law.